Hello, students. Welcome to Module 2 in the Contracts course. This week, we will be having an introduction to the Uniform Commercial Code. We will also be looking at a statement of consideration, one of the elements of a valid contract. We will learn how to create an intake form based on a written scenario or a legal case. We will rewrite contract terms based on an intake form. We're going to learn how to correct defective terms using an intake form. And in your written assignment for this week, we will research possible remedies for breach of contract. Let's get started. So, the Uniform Commercial Code is a set of rules that apply to contracts for the sale of goods or to lease agreements. These provisions are found in Article 2 and Article 2A of the UCC. Most states have adopted the UCC, and they have their own version of the UCC, which you can find in your textbook. A contract may also specify that the UCC rules apply. The Uniform Commercial Code is beneficial because it has special rules for what remedies are available to buyers and sellers in the event of the breach of a sales contract. So, consider a scenario where you have a manufacturer who regularly sells 10,000 cases of a particular wine to a wine distributor. That would be a contract governed by the UCC. And in the event that the seller or the buyer experience a breach, they would look to the UCC for particular remedies. Let's take a look at the specific UCC provisions that govern buyers and sellers' remedies. Usually, the parties to a sales contract owe a duty to perform the obligations as specified in the agreement. That is found in UCC provision 2-301. The seller's general obligation in a sales contract is to transfer and deliver the goods to the buyer. Suppose the general contractor on a construction project routinely needs nails, and he approaches the seller, the owner of a company who sells nails, and they agree for the shipment of 10,000 nails. Under that sales contract, the seller would have a duty to deliver the nails. The buyer would have an obligation to accept the goods and pay for the goods. This is all spelled out in the UCC. When one party breaches a sales contract, the UCC provides the injured party with a variety of pre-litigation and litigation remedies. So you get remedies before you file a lawsuit, and in the event that you need to file a lawsuit, you have additional remedies under the UCC. These remedies are designed to place the injured party in the same position that they would have been if the other party had not breached the contract and instead had fully performed and provided the consideration that the parties agreed to. Let me repeat. The purpose of the UCC remedies are to put the injured party in the same position they would have been if the contract had been perfectly performed. This is described in UCC Rule 1-106. The best remedy will depend on the circumstances of each case. The performance of obligations and remedies available for breach of sales contracts are discussed in detail in Chapter 12 of the textbook, so be sure to read that this week. Let's talk about delivery. This is the seller's obligation, is to transfer or deliver the goods to the buyer in accordance with the sales contract. This is provided in UCC Rule 2-301. Tender of delivery requires the seller to put and hold conforming goods at the buyer's disposition and give the buyer any notification reasonably necessary to enable delivery of the goods. If the goods are placed in a warehouse, the buyer should be given the address for the warehouse. If the goods are coming in on a dock, then the buyer needs to be aware of the location of the dock. Parties may agree as to the time, place, and manner of delivery, so long as it's reasonable. Let's talk about cure. The UCC gives the seller who delivers non-conforming goods an opportunity to cure the nonconformity. If a buyer requests a particular type of screw be delivered and the screws don't fit, the seller under the UCC is afforded an opportunity to cure, and that means to replace or repair the defective or non-conforming goods. Sometimes goods get destroyed in shipment. Not, due to the problem with either party, but maybe the goods are placed in the hands of a third-party carrier, and the third-party carrier, maybe that's the goods are on a semi truck being transported from state to state, and the truck driver loses the load. The goods are destroyed. The seller is given an opportunity to cure by providing replacement goods. A cure may be attempted if the time for performance has not expired, and the seller notifies the buyer of his intention to make a conforming delivery within the contract time. Let's talk about the buyer's obligations. Once the seller has properly tended the delivery, the buyer is obligated to pay, to accept the goods, first of all, and then pay for them. If the goods are conforming, the buyer cannot reject a shipment of goods. That'd be breach of contract. The right of inspection. The buyer has a right to inspect the goods that are tendered, delivered, or identified in the sale contract prior to accepting or paying for them. If the goods are shipped, the inspection takes place shortly after the arrival. If the inspected goods do not conform, the buyer can reject the shipment without paying, and that's in UCC 2-513. Payment. Goods that are accepted must be paid for. UCC 2-607. Unless the parties to a contract agree otherwise, payment is due from the buyer when and where the goods are delivered, even if the place of delivery is the same as the place of shipment. Sometimes the contract provides that the seller go to the buyer, that the buyer sends someone to the seller's warehouse, and that's the place of delivery. If the buyer is going to the seller's warehouse to pick up the goods, payment is due upon delivery. Buyers often purchase goods on credit extended by the seller. Unless the party agrees to other term, the credit period begins to run the time the goods are shipped. A lease. The lessee must pay lease payments in accordance with the lease contract. That's in UCC Article 2A, Rule 516. Revocation of acceptance. The buyer who has accepted goods may revoke his acceptance if the buyer opens the box, finds out that the goods are non-conforming, and the non-conformity substantially impairs the value of the goods to the buyer. and one of the following must be shown. The seller's promise to timely cure is not met. The goods were accepted before the nonconformity was discovered, or the nonconformity was difficult to discover at the time of shipment and acceptance, or if the goods were accepted before the nonconformity was discovered, and the seller has assured the buyer that these goods are conforming. So again, under the UCC, the buyer can revoke the acceptance of non-conforming goods. Well, what are the seller's remedies? The right to withhold delivery. Delivery of goods may be withheld. The seller is in possession of them at the time that the buyer breaches the contract. You know, a contract is a set of mutual promises are enforceable. Should the buyer breach the contract, maybe the buyer hasn't paid for shipment 1. If the buyer hasn't paid for shipment 1, the seller may withhold shipment 2 as a remedy for the buyer's breach of contract. The remedy is available if the buyer wrongfully rejects or revokes acceptance of the goods, fails to make a payment when due, or otherwise repudiates the contract. If the part of the goods under the contract has been delivered when the buyer materially breaches, the seller may withhold delivery of the remaining effective goods. So if the seller is to ship 15 items, the seller ships the first 10, the buyer rejects them, the seller's not required to ship any more. A seller who discovers the buyer is insolvent, buyer files for bankruptcy before the goods are delivered. The seller may refuse to deliver as promised unless the buyer agrees to pay in cash. It's UCC 2-702. Be sure to read that rule, please. So let's get a summary of the buyer's remedies. The UCC provides a variety of remedies to the buyer if the seller breaches that sales contract for the sale of goods. If it gets breached, what can the buyer do? Well, the buyer, again, has a right to reject non-conforming goods or improperly tendered goods, be tendering goods in a place different from what the parties agreed to. The parties agreed to tender of goods in New York, and the seller tenders goods in Paris. The buyer's not required to accept that. What would the buyer do? Send an agent to Paris, to look for the shipment of goods? No. An improper tender. Buyer can reject that. The buyer has the right to recover goods from an insolvent seller. Seller files for bankruptcy and is holding the goods that the buyer needs to complete a project. Buyer has the right to recover the goods. The right to obtain specific performance. So what is specific performance? That's an order of the court directing the seller to perform the contract according to its terms. This is usually important when the item to be shipped is rare, a work of art, antiques, rare coins, or something that unique that the buyer cannot easily, cover by finding replacement goods. So specific performance would be an order from the court directing the seller to perform the contract as written. If the seller refuses that to specifically perform, that is contempt of court, for which the seller could be incarcerated. What are the other buyer's remedies? The right to cover. The seller does not ship goods the buyer needs in a timely manner. The buyer may obtain substitute goods from another seller. The buyer can cancel the contract entirely. And finally, the buyer has the right to sue for money damages in a court of law. Here is a table that summarizes the remedies. You will need to use this to complete your Module 2 written assignment, it would certainly be helpful. What is the Module 2 written assignment? Well, you're considering a scenario where the buyer and the seller have a contract. 2,000 customized parts have been ordered from the seller by the buyer. The price is $1,000 per part. In this scenario, they're customized with painted advertising for the buyer's specific needs. 20 parts have been shipped to the buyer. 10 of them were rejected by the buyer for some reason, 10 were accepted. The buyer doesn't pay for any of the parts. The buyer held all the parts for 10 days and then returned the 10 rejected parts with a message saying they are too large for use, said that the buyer intended to use the acceptable ones, and then obtain cover from a different company. So right now you should be thinking, okay, what UCC rules are coming into play? You can write this down on a piece of paper. And what remedies are available for the seller? What remedies are available for the buyer? What duties to perform have been breached? I would take a moment and jot all of this down on a piece of paper. Again, in your scenario for the written assignment, the buyer and the seller have the master contract. 20 customized parts have been ordered from the seller by the buyer. The price is $1,000 per part. They are customized for the buyer with painted advertising for the buyer's business. 20 parts have been shipped to the buyer. The buyer accepted 10 and rejected 10. Did the buyer have a right to do that? The buyer did not pay for any of the parts. Have any duties been violated? The buyer held all the parts for 10 days and then returned the 10 rejected parts with a message that said they're too large for use. The buyer intended to use the acceptable ones and then simply cover by getting the goods it needs from a different company. Does the UCC allow that? So as you read this scenario, you should definitely take out a piece of paper or open up Microsoft Word or open up your phone and jot down your initial thoughts. What were the seller's duties? Were any of those breached? What were the buyer's duties under the contract? Were any of those breached? In the event that there's been a breach of contract, you should jot down what remedies are available to the seller, what remedies are available to the buyer. So, the written assignment is telling you the seller has the right to cure any defect in parts within 10 days of notification of the defect to the seller and the return of the defective parts. The seller does not cure within 10 days. The buyer may cover parts from any other source. This paragraph in the contract is not intended to add or change any UCC remedies that would otherwise be available, just giving a time limit for the period of cure. So the following questions need to be answered by you in your Module 2 written assignment. Define, cover, and cure under the UCC in your own words. Within the context of this contract, be sure to cite the UCC provision that you're paraphrasing. Complete the italicized portion of the IRAC table provided in the assignment. Use the scenario, the UCC, and the details of the master contract. And then finally, select a fix for Clause 3 of the master contract and explain why you chose to modify the contract. So this is a great assignment. This is really giving you a chance to show off your UCC skills. So just a reminder, everyone, we will have our live classroom as scheduled Wednesday at 6 p.m. Central Standard Time. Use the following link to join, cut and paste that into your web browser. This live session will give us an opportunity to learn more about the UCC provisions, to talk about the Module 2 written assignment in detail. We'll look at the grading rubric. We will also be analyzing the IRAC method for writing about legal problems. This is something that you will need to do. Again, if you have any questions or concerns, feel free to reach out to me via email or send me a text message. My e-door is always available to you. And have a great week, everyone. I will see you in the live session on Wednesday. Thanks.